सर, सिंस यू आर हियर, हम लोग तो बात करते रहेंगे पत्रकार के नज़रिए से। सर, हम लोग आपको सुनेंगे भी और तैयार रहिएगा, आपको घेरने की भी थोड़ी कोशिश करेंगे। लेकिन एक आपने जब सर सुप्रीम कोर्ट में थे, आपने भी काफ़ी प्रैक्टिस की और आपका वो स्पीच भी हम लोग को याद है। किस तरह का अनुभव रहा, एक बार ज़रूर सर के सामने हम सुनना चाहेंगे।
You see, Honorable Justice Hemant Gupta, sir, was a very famous lawyer in Punjab and Haryana High Court. He was an authority on civil law, and it's not my wordings. I had spoken to several other judges, some of them who became Supreme Court Chief Justice, and some of them they became judge. They all had high regards for him, especially in the civil matters. But they all at the same time appreciated that despite having not dealt with so many matters in the criminal side, when Honorable Sir was judge in the High Court, he had delivered lot of great judgments in the criminal side. He has when he was a young lawyer, at that time only he developed a habit of working hard, and he started his life from those days 5 a.m. to 11 p.m. It's very tough life. As a judge, when Lordship was there in the Supreme Court, most of the clerks, interns who were working with Lordship, they used to appreciate, and they say, sir, आप कहीं बाहर जाने को तो मिलता नहीं है, सर सुबह जग जाते हैं, देर रात तक पढ़ते हैं, उनके साथ हम लोग को भी रहना पड़ता है. It's a very good thing. Actually, they should always be grateful for him in the next of their career because they had found such a great judge. Normally, what happens if somebody is doing a lot of work, then almost all the responsibilities are given to him only. And they also will start taking their work so seriously because their name and credibility and the ability and thereafter imparting the education, everything is part of it. Recently, when I was there in some program and then we went to Christ University, we met there on the second time, I saw sir has a great passion for young students. And he always believes that young students should be actually taught properly. They should understand the subject because they are the future of our next judiciary. And they are going to perform in all the categories and sphere of life. Lordship's father was also Chief Justice. He was a very principled man. And he resigned from the post being the Chief Justice. And he said whatever he believed, he used to say that. Lordship also, he has performed in all kind of businesses of related to law and lawyers. And he never felt at any moment that he should deviate from the duties which has been assigned to him. Whatever pressure may be, whatever the relations may be, but Lordship always taken care of the responsibility which had been bestowed on him by the Constitution. So we are actually very happy and we are lucky to have him, and not me. I am also here as one of the viewer only, and today I am going to listen Honorable Lordship. But you all are also lucky to have such a wonderful person, such a knowledgeable person. Even today itself, while the interns meeting, I was saying that if you are doing well in arbitration and if you aspire to become a good arbitration lawyer or participating in those processes, you should have command over civil law. So Lordship is here, and I'm not going to come between Lordship and you all, and we all have to enjoy, we all have to go, we are going to have a wonderful experience today because his words of wisdom is actually going to enlighten us, especially on so many subjects which you may not have explored or which you may not have found the opportunity to deal with. I am really grateful, sir, that you are here, and today we all are sitting here as your student. Thank you so much, sir.
So, अब हम सेशन की शुरुआत करते हैं. सबसे पहले मैं प्रारूप समझा दूं. सबसे पहले जस्टिस हेमंत गुप्ता की वो बातें जो कि न केवल हमारे न्यायिक व्यवस्था के बारे में होंगी, बल्कि भविष्य को कैसे हम और एक बेहतर न्यायिक व्यवस्था की ओर हम बढ़ सकते हैं वो भी, और साथ ही उसमें नए प्रयोग कैसे किए जा सकते हैं आर्बिट्रेशन मीडिएशन के द्वारा, वो सारी बातें जस्टिस हेमंत गुप्ता और अपने अनुभव तो साझा करेंगे ही। उसके बाद हम क्वेश्चन आंसर का सेशन स्टार्ट करेंगे, जिसमें आप सभी लोग अपने अपने सवालों के साथ तैयार रह सकते हैं और आपके अंदर जो जिज्ञासाएं हैं वो आप शांत कर सकते हैं। और जैसे हेमंत गुप्ता, मैं बता दूं कि जो हमारी संस्था है वो संस्था न्यायिक व्यवस्था पर, न्यायिक रिपोर्टिंग पर काफ़ी काम करती आई है, और इंडिया लीगल रिसर्च फाउंडेशन जो हमारा है वो लीगल एड पे बहुत काम करता रहा है और आज भी हम कर रहे हैं। इस समूह में सर आप लगातार नए अधिवक्ताओं को तो देख ही रहे हैं, कुछ पत्रकार भी हैं जो अलग अलग संस्थानों से भी हैं, और उन सभी के अंदर कई जिज्ञासाएं हैं जिसको आपको आज एक तरह से शब्द देना है। तो सर अब आप हमें ज़रूर अपनी बातों से इनलाइटन करें।
Namaskar, good evening. Now, I am happy to see young students. May I just say that, find out that all are fourth year, fifth year students or have passed law? Acha, okay, good, good. Okay. You know, when I decided to come here, I had no intention of saying anything. I was told that there would be a question answer session. But last evening, Sanjay Sinha called me, says, I have to speak something. I have not prepared any text, any speech. I will say, if you want on a particular topic, I will like to share my experiences of that field. Otherwise, I will speak on arbitration. Yes. Arbitration, you must have heard, Madhyastha, is a very commonly used word and adjudicatory process, but it has many challenges. In the Code of Civil Procedure, before 1908 CPC, there was a provision of arbitration in the old Act, old Code. But subsequently it was removed. The Arbitration Act came into picture in 1940. And that 1940 Act was repealed in 1996. The 96 Act takes into consideration mediation, conciliation, and arbitration. Arbitration is adjudicatory process where somebody acting as an arbitrator decides the dispute, whereas mediation and conciliation are voluntary settlement with the intervention of a third person. But it is a voluntary settlement, whereas the arbitration is adjudicatory. Our 1996 Act has been amended thrice in 2015, 2019, and 2021. But it has still many challenges. What you will hear about the arbitration is, it is ad hoc arbitration generally, where the court appoints an arbitrator under section 11(6) of the Arbitration and Conciliation Act, where earlier it was titled as Chief Justice of the High Court or Chief Justice of India in the case of international disputes. Now it was changed to the High Court or the Supreme Court. But the fact remains that arbitrators are appointed by the court. If there is no agreement, the arbitrators are appointed by the court. There is unknown clause in section 11(5) and 11(6), where the Chief Justice earlier, now the High Court or the Supreme Court, can designate an institution also to appoint arbitrators. You know, I must have read section 11(6) couple of times, but this part, that the institution could also be designated was not known to me, to be honest. I was lucky. Two Honorable Chief Justices of my parent High Court have designated me as delegated me the power of the Chief Justice to appoint arbitrator. I exercised that power for a year each, for almost 2 years. But this fact, nobody argued it, nobody knew it, and actually there was no institution in Punjab and Haryana, I would say so. But I was in 2 other courts, there was also no institution. Delhi has one institution, Delhi International Arbitration Center. Mumbai has one, Hyderabad has one, there are many others. But the court generally appoints the retired judges as the arbitrator. There are certain advantages of the retired judges, but certain disadvantages also. In ad hoc arbitration, there is no cap that how many hearings will take place, how much time. Recently in 2019, they fixed time, but still, generally it crosses that time limit. But fee is again made part of Schedule 4, that is 30 lakhs, that is upper cap. But recently, Supreme Court in a judgment, ONGC versus AFCON, said 30 lakhs is fee which is applicable to claim and counterclaim. So it comes out to be, in a given case, it can come out to be 60 lakhs. But this fee, 4th schedule, is not applicable to the institutional arbitration. Delhi High Court in Delhi International Arbitration Center is managed by the sitting judges of the Delhi High Court. They have framed new regulations for conduct of arbitration, which are applicable from today. 1st of April is the date of commencement. They have fixed the fee, cap of the fee is 60 lakhs. But fee is only one part. The fact is, I'm not very sure that in how many cases Delhi High Court has nominated or designated an institution as an arbitrator. I was appointed as an arbitrator by Delhi High Court, not as institutional appointed. Delhi High Court appointed me. There are many other instances where High Court is appointing individuals as arbitrators and not the institutions. In respect of institution, the fee is known beforehand, that this will be fee payable, and also the timeline is fixed under the act also, but still you will like to maintain the timeline. But basic advantage between ad hoc arbitration and institutional arbitration is that where in ad hoc arbitration there is no limit that how many sittings you will conduct, whereas in institutional arbitration, whatever sittings you conduct, there is a cap of the maximum fee which will be paid, and everything is known beforehand. Nobody can have a grievance that I was charged extra. There is a constant problem about high charging of a fee. Like in ONGC case, also the public sector was aggrieved against the charging of fee by the arbitrator. Somewhat similar matter came up before me in the High Court against raising a grievance of charging of a fee by the tribunal, 3-member tribunal. If I remember correctly, their grievance was that 80 lakhs has been paid as a fee, but still the stage of issues have not come. They wanted to seek the termination of the mandate of the arbitrators so that it can be decided by civil court. As in Delhi, there is the original jurisdiction. In Punjab, there is no original jurisdiction with the High Court. So question is that such application would be ordinarily maintainable before the original jurisdiction, that is a district judge. I said that you have to go before the district judge. But their grievance was that the tribunal consists of 2 retired Supreme Court judges and another retired judge of the High Court. We can't go to the district judge. It will be very embarrassing for us and for the arbitrator to go before the arbitrator. So after hearing learned counsel for the parties, I decided, we are governed by the latest patent, that is Royal Charter of the King, where there is a clause that the High Court can withdraw any case or permit the parties to file original suit before the High Court. So I allowed them to entertain that application in the original jurisdiction of the High Court. So naturally, one party was not happy about it. They came before the Supreme Court. In the Supreme Court, they didn't go into the merits of the controversy. They agreed for appointment of a sole arbitrator. That finished, the arbitrator has given the award and other things. These are the issues which come up before the ad hoc arbitration. No cap of fee, no cap of hearings, so which lead to multiple issues. So therefore, generally people say if you read, go to the websites, you will find ad hoc arbitration is cheaper, it is faster, but the practical experience is otherwise. One of the lawyers told me that one of the ad hoc arbitrator was paid a fee of 70 lakhs. And still there was a demand of 15 lakhs as a reading fee. The parties have no option. If they don't pay the fee, even their 70 lakhs go down the drain, because the new arbitrator, even if appointed, will demand the same fee again. So they had to pay. Should have paid, I do not know. I will not say anything about that. But the question is, ad hoc arbitration has pitfalls. On the other side, institutional arbitration is promising. I'm told there are about 35 institutions in India dealing with arbitration. 3 of them I have named: Delhi, Bombay, Hyderabad. There is a Gujarat is starting another one. Goa is starting another one. There are many others. There is a FICCI mandated arbitration, Indian Council of Arbitration. They are also in field. The idea is that institutional arbitration should be able to provide the dispute resolution in a known method, and which can be speedier. Of course, it will depend upon the quality of the arbitrators which we associate with. And for association of arbitrators, we have framed the regulations. We have a very esteemed panel of known national and international arbitrators. Justice Sikri is one, Justice Indu Malhotra is one, Mr. Salimullah, who is a King's Counsel in London, is one Sherina Petit is one. There are many others they are total of 10. So with that level of the members who will impanel arbitrators, we can be sure of quality impanelment of the arbitrators. Another thing is that in one of the seminars, Chief Justice of India said that this old boys club syndrome should not be there. One can know what is meant by the old boys club. I will not elaborate on that, but to meet that objection, or maybe the mindset, we have made eligible the candidates from the age of 35 to 75 as the arbitrators. Why can't a young lawyer with some experience of, generally you will join a profession at the age of 24, 23. So if you have gained an experience of 10, 11 years as a lawyer professional, why can't we trust you as an arbitrator? Why can't a chartered accountant be trusted as an arbitrator? Why can't an engineer be trusted as an arbitrator? So if we rely upon such young blood, probably the face of arbitration in India will change. Just for your information, in worldwide, the retired judges are not the sole arbitrators. They are all from different professions working as arbitrators. So same, I think, mindset we need to develop in India, where the persons from varied fields can work as arbitrator. Their experience, their, without any baggage, it will be better for the arbitration. There are other issues which faces Indian arbitration system is post-award. Post-award is section 34, objections are filed, which are not decided for long time. I just want to share one case. There was an Australian company by the name of White Industries. They entered into an agreement with Coal India. So the award went against Coal India, but the objections were filed. Objections were filed before two forums, Delhi and some other. Objections were not decided. India is signatory to Bilateral Investment Treaty, BIT. The White Industries invoked the jurisdiction of BIT to say that Indian judicial system is not effective. Therefore, we have failed to get a redressal of our grievances for Indian system. The award went against India, and Indian government has to pay White Industries the amount of the award, which possibly could have been paid by Coal India, or whatever, good, bad, indifferent, the decision had to be there. There was no decision. So these are the issues which arise. Our legal system is known for delays, but the arbitration can change. The arbitration, there are multiple forums of appeals against the award of the tribunal also. Firstly, before district judge, like in Delhi High Court, it will go before the single bench, then intra-court appeal, then Supreme Court, 3 forums. Same thing before the other high courts where there is no original jurisdiction, like in Punjab. The objections will be filed before district judge, appeal will come to the High Court, and then second appeal or special petition will come to the Supreme Court. So multiple forums delays the finality of decision. The grounds of challenge is if the award is against the fundamental public policy of India. It's quite vague, indefinite, and then it was interpreted as if the award suffers from patent illegality, it will be ground for challenge. What is patent illegality is again not very clear. So under the the ground of patent illegality was taken away in respect of objections against the award of the international arbitration, but against the domestic awards, they are still available. So there are multiple issues. Whatever you may say, in one of the conferences, one of the panelists said that in England, 20 awards were given, 5 objections were accepted. So I said that even if 5 objections, even if in one case the objections are accepted, means that arbitrators are not infallible. They can commit a mistake. So therefore, we can't permit the arbitrators to be arbitrary also. So there has to be a ground of challenge. Only thing is that the satisfaction of the court should be recorded at the earliest so that there is a quick decision, finality to the dispute. That's what I would like to say. Now I will throw the
सर इसके पहले कि बाकी लोग अपना सवाल करें, जब आप सर ये बोल रहे थे, मैं लगातार सोच रही थी कि जिस तरह से सिंगापुर, दुबई जैसी जगह भी जो जानी जाती थी सर कि तमाम अन्य चीज़ों के लिए, पर आर्बिट्रेशन के लिए नहीं, उन सबों ने एक अपनी रेपुटेशन बनाई। आज जब आप उस पोजीशन में हैं, बहुत सारे चैलेंजेस आप देख रहे हैं, लेकिन जो मुख्य वजह है कि क्यों, क्या आपको लगता है कि हम ब्रांड अपने आप को नहीं कर पा रहे हैं एज आर्बिट्रेशन सेंटर? इंडिया जो है वो अपने आप को उस तरह से बाहर ले नहीं जा पा रही है, इसलिए विश्वास नहीं हो रहा है, या इसकी वजह ये भी है कि ओवरऑल एक माहौल ऐसा है भारत में कि केसेस में डिले होती है? ये सब कुछ ने आर्बिट्रेशन और मीडिएशन की संभावनाओं को भी यहाँ कम कर दिया है।
The basic problem is twofold. Firstly, there's delay of appointment of an arbitrator alone. I come from Punjab. I am told, I am not very sure, the appointment of arbitrator applications are pending for almost 3 years. These are the administrative orders. Supreme Court in State Bank of Patiala versus Patel Engineering has said these are administrative orders. But the problem is with the judges is the principle of natural justice is embedded in us. We will not pass an order unless we give opportunity, we seek counter affidavit, and then rejoinder affidavit. That takes comparatively long time. I remember I was in Patna, a case came about the custody of child, minor child, toddler child. The couple came from abroad to take the physical custody of the child. They were staying in the hotel in some remote district of Patna. The matter was not decided. 3 months they were staying to take the custody of the child. It came to my notice, it was brought to my notice that this matter is pending. So I tried to speak to the district judge, not me, but the office. He says, I will decide, but I don't know how much time it has taken. Then I told the general manager of CARA, that is Child Adoption and Regulatory Authority, that these powers, if you confer on the court will decide as per the principles of natural justice. It will hear the other side. Without hearing, there is no administrative order where you say as at X or as at Y. The judicial officers can't do that order. I suggested you amend the act, give this power to the district magistrates so that they can possibly approve the adoption at an early date. The act was amended later on, where the power of approval of the custody was given to the district magistrate. It's only to facilitate, the child is in in some children home, small child, 3 months, 4 months, who will take care of that child? He will lose, he or she will, her health would be in problem, her upbringing will be in problem, and there are persons who want to take the child. Reject it if you don't file it, but you must decide it. So that is the problem with the appointment of arbitrator, because we don't, we have to decide in a judicious manner, though it is not a judicial function, but we can't decide it other than in judicious manner. So that is one difficulty. After appointment of an arbitrator, the judges of the High Court, Chief Justice of the High Court, or the judges of the High Court whom the Chief Justice delegates the power of appointment, they don't have any pool of arbitrators. Their pool is only the retired judges, retired High Court judges, retired district judges, or whatever. The advocates are never appointed. So the process of appointment and then conduct of arbitration becomes a challenge. And the father of all problems is post-award, Section 34.
And Old Boys Club. So questions start करते हैं. Yes.
Sir, my question is basically the Bar Council of India. Sir, basically my question is the Bar Council of India has allowed the entry of foreign firms and lawyers to practice in India, right? The thing is, how is going to affect the arbitration scenario in India? And can we say that because of this single step, can India emerge as an arbitration hub, sir?
The foreign lawyers, as on now also, Indian disputes, when they are handled by Singapore Center or London or Hong Kong or Dubai, the foreign lawyers assist the Indian parties. So what is being done indirectly in foreign jurisdiction, that will be done in India. Is only the foreign lawyers are permitted to practice before they are in the international arbitration in India. So they were already doing it. Indian parties were taking the benefit of their services in other forums. Why can't we take the benefit? And one thing, Indian lawyers are not less than anybody else. Best of brains, very hardworking, sincere. If they have a competition or foreign lawyers come, probably their quality will also improve. They will be still better. So that's what I don't see any challenge or threat to Indian lawyers.
So जो नए बच्चे हैं उनको ये सीखने की ज़रूरत है कि पढ़ने की बहुत ज़रूरत है. अब आपका जो कॉम्पिटिशन है वो अंतर्राष्ट्रीय स्तर पर रहेगा, एंड इट्स अ गुड सर. इनफैक्ट जो भी अच्छा करेंगे वो आगे बढ़ेंगे. नेक्स्ट क्वेश्चन.
Hello, sir. Sir, you talked about the challenges in the Arbitration Act and especially about the ad hoc arbitrations. Now, in 2019, one section was inserted, 42A, regarding the confidentiality of the arbitration. So in 42A, the only 3 aspects were covered: arbitrator, the arbitral institution, and the parties to the agreement. I think if you can enlighten us regarding the confidentiality of agreement and applicability of section 42A regarding the ad hoc arbitrations.
The confidentiality is the basic norm. Therefore, you will not find the awards can be published. They are not in public domain. But Delhi High Court has permitted that they will publish the awards. It should not be done. They may mask the party's name, but otherwise, but from the reading of the dispute, you can make out. What is permitted under the Act was that when you file objections that award can be made public, not the proceedings which are taken. The party autonomy, party confidentiality are the hallmark of arbitration. In the 2019 amendment, there is provision for setting up Arbitration Council of India. Arbitration Council of India will regulate the arbitral institutions and arbitrators. So far, the government has not appointed any chairperson of that Arbitration Council of India. But confidentiality is not negotiable.
Next. Yes. Yes, Mike, वहाँ दे दो. Yes, please.
Sir, as you have mentioned about the foreign awards and how it can be enforced in India, as the cases like the recent case of Vedanta case, Government of India versus Vedanta, has this made any significant changes to that particular domain? And is the enforcement powers that are given to the awards, is it sufficient in Indian scenario?
If I remember correctly, Vedanta was settled ultimately by the government. But the fact is that execution of the award, if you want to execute against the award, against the property of Indian company, you have to come to India. So therefore that problem still remains. The execution in civil law, it says the real problem of the decree holder starts when he wants to execute the decree. So that problem is there. I can mention another matter. Antariksh versus Davos. There was an award given by the arbitral tribunal in London. It was probably 15,000 crores or something. The government of India sought the winding up of Davos on the ground that the base company has been established in a fraudulent manner. So that plea was accepted by the NCLT, affirmed by NCLAT, and affirmed by the Supreme Court. Now thereafter what happens is, they attached some of the shareholders sought the attachment of the property of India in US and other countries, where like Air India was a government company, so they attached the planes of Air India. So that problem would remain, that how to execute, how not to execute, whether the property can be a property of Indian companies. It is only Government of India properties were there, but you will not find any Indian company. Maybe Mahindra has a setup in US where they have set up a manufacturing plant, but other companies may not have. Like Tata's have a manufacturing plant in London, but other companies may not have asset in other companies. And these companies, Tata or Mahindra, will not go into the arbitration. They will settle it beforehand.
And sir, please.
Good afternoon, sir. This is Ravi Shankar. Sir, government is working on the ease of doing business in India, and lot of FDIs is coming and in the global scenario. So what do you suggest to the government, how they improve the international arbitration system so that India can got a lot of confidence?
The government of India has created an international arbitration center, appointed me as a chairperson. Whether I am able to do good or bad, time will tell. But I am trying to do my best. So government is contributing in its own way. But the problem of Indian arbitration is the way we have grown with the arbitration mentality since the time 1940 Act. 1940 Act also empowered the court to appoint arbitrator. There was no qualification. The court in that case was even the sub-judge. So there was a mindset. We have grown with the mindset of the court appointing an arbitrator. It will take some time to change that mindset, that instead of a court, the institution appointing an arbitrator. But you are right, it's mindset issues are real issues which need to be settled.
सर एक और बड़ा सवाल है कि प्रॉपर लॉ, लैक ऑफ प्रॉपर लॉ इन द आर्बिट्रेशन फील्ड, दैट इज आल्सो अ प्रॉब्लम सर, डू यू थिंक सो?
The law is, I won't say the law is not proper, only thing is multiple forums of challenging an award. You go to the district judge, you go to the, there are 3 forums and everybody wants to avail. You know, international arbitration, they are huge, 1,000 crores, 10,000 crores or something of that kind. So people will avail to challenge it, will try to challenge it. I don't know how, I'm not very sure, either to reduce the challenge forums or another advantage of institutional arbitration is institutional arbitration has an in-house check of awards. The awards are seen by the institution, generally clerical or arithmetical mistake, but there is some review of something which will ensure that there is a quality of award is there. There is also provision of arbitration academy in our act. So if the arbitrators are trained to how to conduct arbitration, that would also improve the quality of arbitration. Say if a young lawyer at age of 35 is given an arbitration, by the time he's 40, 50, he must have undertaken 10 or 15 arbitrations. That will give him experience. That will make him more robust in deciding arbitration in a better way.
तो यहाँ पे एक बार और मैं जरूर जानना चाहूँगी आप लोगों से कि क्या आप लोग जब पढ़ाई करते हैं, लॉ की पढ़ाई में आर्बिट्रेशन के ऊपर स्पेशली कोई फोर्स दिया जाता है कि आप जब लॉयर बन जाएं तो आर्बिट्रेटर बनने की कोशिश करें? कोई इस तरह के स्पेशल क्लासेस आपको होते हैं कॉलेजेस में? So introduction about this also, sir, we really need.
No, as I know, probably Arbitration and Conciliation Act is taught, but not that how do you practice as an arbitrator. There is Indian Institute of Management, which has a 5-year law course. We are discussing whether to have an MOU with that, where they are proposing that we'll train arbitrators, we'll give diploma and the diploma or the certificate course in the after training of arbitrators. If that process is complete, it will help the youngsters quite a bit.
और सर आप जब बात कर रहे थे कि आर्बिट्रेटर्स डिफरेंट फील्ड से भी होने चाहिए, इंजीनियर्स भी और तमाम और एक्सपर्ट्स भी, मैं बस ये सोच रही थी सर, ये क्या मीडिया वालों को भी आप एज ए आर्बिट्रेटर देखना चाहेंगे?
Yes, in case of media disputes, yes.
और सवाल?
Good evening, sir. I'm Krishna Rajit, Deputy Editor with the Pioneer newspaper. Sir, you have an illustrious career, and in fact, presently you are the chairman of Arbitration Council. Before that, you successfully served as Supreme Court judge for 4 years. Earlier, you were Chief Justice of Madhya Pradesh High Court. Before that, you served as judge in Patna High Court and Haryana and Punjab High Court. Sir, which stint did you enjoy the most? And why, sir?
I I was judge for almost 20 years.
Yes, sir.
I enjoyed each day as I enjoyed on 2nd of July 2002 till 14th of October or 15th of October, the last day. My zeal was never diminished, never diminished. As a lawyer also, you know, I used to work. That habit continued as a judge also. So I don't say that I enjoyed Patna more or Madhya Pradesh more. Each experience was different. It was a learning experience for me. It was good learning experience for me of going to different courts, learning the best practices. You know, I give you example. When I went to Patna, they had a different listing system. In Chandigarh, we have each case of motion hearing or the miscellaneous matters as is called in Supreme Court has a date fixed. So each matter will come on a particular day. But in most of the high courts, including in Supreme Court, the miscellaneous matters, there is no date fixed. The court order is list after 2 weeks, 4 weeks, 6 weeks, whatever. And people will try invariably for listing of the case. When I went there, it was quite a surprise for me. Then, you know, I realized that I'm the only new person in the entire system. Why should I try to change it? I need to adjust to the new system. So when I became Chief Justice, Acting Chief Justice, the first day there were probably 20 mentions of listing of their matter. And almost equal number of saying that our matter should not be listed. I decided in 5 seconds that all granted, all mentions granted. Those who want to get their case listed will list their cases. Those who don't want to list their cases, let them go. So why waste time on something which is so ministerial?
Good evening, sir. I'm Vikram here. Given your experience in the Supreme Court, and if further down time, Parliament decides to have a court of appeals, like in the US, how will it impact arbitration?
The Court of Appeal?
Yeah.
No, Court of Appeal will not. Court of Appeal will not impact arbitration because arbitration is not part of the court system. It's only enforceability of the award will become part of the system. Court of Appeal should be there or not there. The previous Attorney General was very keen there should be Court of Appeal.
Yes.
I'm not very sure how practical that solution is. There was another suggestion that since the workload of Supreme Court is much, we should have a middle level forum where the criminal appeals, actually that was the suggestion made for the high courts, that criminal appeals are pending in the high courts for 10 years, 15 years. So we should have a middle level bench of district judges, 2 or 3 district judges be decide, let them sit together and decide it. But there was no taker for that. The Court of Appeal will not affect the arbitration.
Pendency-wise?
Pendency-wise, if there is a forum of deciding civil disputes, is better, but it will. No, we were. I was discussing with ma'am that how Singapore became known for arbitration. A Chief Justice was appointed somewhere in 91, 92. His task was to streamline the working of the Singapore system of judicial system. It was hence, before that it was same as India, delay and other things. He said that 3 issues have to be decided by courts, like criminal matter and matrimonial matter. Why the Supreme Court or the criminal or the judicial court should decide the commercial dispute between two individual entities. If they have a dispute, let them settle it. in the independent forum. What was devised was that for 2 days initially it was free. For the third day the expenses, it was some fee was charged. Fourth day it was still higher, and fifth day it was still higher. That compelled the parties to go in for arbitration. That's what my information is. I am not very sure how far it is correct.
In hindsight, how did you react to the media reactions to the hijab judgment, if you'd like to say?
I've forgotten.
That's fine.
Good evening, sir. So I was just having a search on Google, just like any journalist typical. Just my name is Mihir, sir. So I got a very interesting data. It suggests that your annual, judgment writing rate was 50.75, and that is the third best in Supreme Court. Only Mr. Justice Chandrachud and Justice Amar Shah. So what it makes you, is just something which is actually extraordinary. So what is that thing? Seeing the pendency of cases in various courts, even Supreme Courts are overburdened sometimes, and that is the problem. So these pendency of cases, so how actually, what are the suggestions you want to share? Because this has been concerned more or less.
My number of judgments is only incidental.
Mm-hmm.
I was given opportunity to write by my senior judges. I wrote them.
Mm-hmm.
As a senior judge, I got the opportunity. I wrote some, given some to the others. So it is opportunity only, it's matter, nothing special about it. The media has to create a news, that's.
Okay.
But
so, sir, sorry, please continue.
But what you are saying is that, sorry, I missed your question also.
Oh, my question was that your annual, judgment writing, that is percentage is more than 50%. Only two Justice Chandrachud. So what it makes actually you are so seeing the pendency of cases as far as various courts are concerned.
No, it has nothing to do with pendency of cases. It only talks about the 50% cases, my judgments. It only shows that whatever cases came up before us, out of that 50% judgments were dictated by me. But that doesn't deal with the issue of pendency. Pendency is a separate issue. As a puisne judge, I have no control which matter will be listed before me. If a matter has been listed before me, I was stingy about adjournments. That's all I would say. I would like to hear the parties and then take up. That is the only thing, nothing more than that.
Okay, sir. As a typical journalist, so was there any challenging moments? Of course, you must have seen a lot of challenging moments. But if you want to share with us any such challenging judgment, challenging verdict, something like that, there are a lot of media pressure, media circus, just like.
One of the most challenging judgment was Kandahar hijacking. The Indian Airlines plane was hijacked, taken to Kandahar, and then the terrorists were released. The FIR in that case was registered at Amritsar because that was first landing point in India. And then the terrorist made the pilot to fly that aircraft. That was a challenging judgment in the sense the issues which came up, legal issues, starting from the issue of whether the legal aid was provided to the accused at the time of recording of confessional statement. And also whether the argument raised was that there is an Anti-Hijacking Act and there is no charge or offense of conspiracy in the anti-hijacking. So our argument was that the person who were arrested were not really the kidnapper or the hijackers. They were the ground level help providing, only one person. There two were Nepalis who provided the hand grenade or something of that kind. So the argument was that unless the conspiracy is mentioned as an offense under the Anti-Hijacking Act, I can't be convicted for an offense under that act. So we had dealt with that and their argument was that India is signatory to International Covenant of Anti-Hijacking. Since that provides for conspiracy, since Indian Act has not provided for conspiracy, I can't be convicted for conspiracy. So we decided that no, conspiracy is an offense under the IPC, and Anti-Hijacking Act is not exhaustive of the complete, it's not a complete code. It's the offense under the IPC can still be made out. That is the level of disputes which arose in that. It was, remember that. There are many other judgments also. As a lawyer, I remember I was appearing for the state. There was a contempt proceedings against the Secretary of the State. The Secretary of the State insisted on one particular stand which the Advocate General didn't agree. So Advocate General gave it to me that you handle it, because I can't make him agree on what I say. So when I saw the brief, I said that it is actually contemptuous. The man would be in trouble. So I called him and says, you will be in trouble. The kind of affidavit you have filed. He says, what do I do? He says, I will prepare a draft affidavit. You see it, sign it, and then we'll see to it. We filed it next day. The court, I persuaded the court that we have done blah, blah, whatever. And the lawyer was keen to refer to the previous affidavit. I didn't allow the court to come to the affidavit. I said that let be finalized. These are the issues which you remember, in the hindsight, that how you deal with a particular situation.
सर, लेकिन आज जिस तरह से सोशल मीडिया का ज़माना है और जब जजमेंट्स आते हैं, और न केवल जजमेंट्स पे, जजेज की भी आलोचना लगातार हम सोशल मीडिया पे देखते हैं। ऐसी तमाम ख़बरें भी आ जाती हैं जिसमें बेसिर पैर की भी बहुत हद तक वो ख़बरें होती हैं। किस तरह से जजेज इस बात से डील करें, जिस तरह के रिएक्शंस हम देख रहे हैं लगातार?
The social media, you can criticize the judgments, but one should refrain from criticizing the judge. That distinction between criticizing the judgment and criticizing the judge has actually vanished. That should not be there. The personal attacks, which should not be there. But social media, right of freedom of speech and expression, you can say anything at any point of time and get away with it, unless it is defamatory.
Yeah.
Hello. Good afternoon, sir. So first of all, I would like to thank ma'am and sir, both of you, for providing us with the opportunity to interact with Hemant sir. And sir, my question to you is, sir, as you said, appointment of arbitrator is one of the main reasons India is lagging behind Dubai and Singapore in the field of arbitration. So what do you find, how do AI can help us in propelling this system, and so that we can catch with both Dubai and Singapore?
I have not examined how the AIA can help, but AIA can't be given power to write orders. That can't. I read in the newspaper that one of the judge has sought that what should be parameters of grant of bail in a serious offense. But that may be an innovative idea, but I don't think so, that artificial intelligence can be used for deciding cases. For the processes, yes, we can do that, but I have not examined it. I will keep it in mind that how to make use of it.
और सर इसके पहले कि आपके पास दूसरे सवाल आए, बहुत सारी लड़कियां भी बैठी हैं. दो ये कहना नहीं चाहिए कि पर्सनली आई बिलीव कि न्याय लीगल सिस्टम में देर इज़ नो कोई डिफरेंस नहीं है, चाहे वो लड़का हो या लड़की हो, अल्टीमेटली टैलेंट होना चाहिए. पर जैसे जैसे सुप्रीम कोर्ट में बहुत सारी ये बहुत इसके लिए अपने ऊपर लिया गया कि भाई महिलाएं आ गई हैं और अब तो हमें चीफ जस्टिस ऑफ इंडिया भी पहली महिला मिलने वाली हैं. आर्बिट्रेशन की दुनिया में भी क्या लड़कियों के लिए कोई स्पेशल जगह आप बनाएंगे?
We treat everybody equal. If the girls are competent to act as an arbitrator, we will welcome that. You know, there was a time when I joined profession, there was hardly anybody. In my section, there were only 3 girls out of 60 boys. The time has changed. You will find in law more than 50% of any class are the girls. More than 50% of the new entrants in subordinate judiciary as a civil judge are the females. So they will change the face of the litigation, maybe after 10 years, 15 years. Those civil judges, junior division, by the time they will become high court judges, it will be 25 years later. Probably at that point of time, there will be maybe 100% lady judges. We don't know what will be the situation. But I remember there was one lawyer in Chandigarh, very energetic lady lawyer. There was a conference organized by the women lawyers to say that we should be elevated as the judges. So she said that, she spoke in that. She says that, no, why should I get any benefit of my gender to become a judge? I should be competent enough to be a judge. That is also one argument. But 2 things equal, I would prefer a girl to be a judge. But you can't say that in the intelligence level or the working level you are at a yardstick number 25 and the other is at 75, you should be equated with that. That will not be fair for the litigants who will come before you.
सर और एक और सर सवाल, चूँकि आप हैं सर और सुप्रीम कोर्ट की बात चली, आपके अपने एक्सपीरियंस की बात चली, हम सभी मीडिया वाले आजकल बहुत शिद्दत से जानना चाहते हैं कि कॉलेजियम में क्या होता है.
Fortunately, I was never part of collegium. So I can't say anything about the collegium. I was not part of the collegium of Punjab High Court also. I got transferred earlier. I was part of the collegium of Patna High Court and Madhya Pradesh High Court. There was nothing, no fireworks, I would only say.
Sir.
Sir, is there any possibility of setting up arbitration councils in smaller cities as well, like grade 2 cities?
Arbitration council?
Yeah, like we have Delhi Arbitration Council. So in smaller cities also we'll have centers.
The mandate given to us, our center, that's the India International Arbitration Center, is pan-India.
Right, sir.
So we'll be impaneling arbitrators from all over the country. And we are giving choice to the arbitrators to conduct proceedings either through video conferencing or at the place of their, we are asking for 3 choices, the preferred choice of venue. So that there will be. What we are proposing is completely paperless arbitration. everything would be through can be through video conferencing and through on the basis of soft copies.
Good evening, sir. I'm really grateful that you're able to give us this speech on arbitration. My main question is that ever since the onset of COVID, we have seen a rise of online dispute resolution through video conferencing, as you just said. Now, from your opinion, from your viewpoint, from your perspective, what do you think would be the pros and cons of online dispute resolution as compared to offline arbitration? And another question, if I just may ask, you said that the mindset of arbitrators is not there in India yet, as compared to Singapore and Dubai and London. So what can we introduce skill set learning at the school level or something of that sort to inculcate some sort of a mindset for arbitrators per se?
You know, the online proceedings have their own advantage. The traveling time, these arrangements, sitting, night stay, etc., there everything is saved. It's less expensive to the parties. But we have done many matters through video conferencing. I was member of the bench which decided Maratha reservation in Maharashtra. The entire hearing of the constitutional bench was conducted online, so there was no difficulty. If that level can be proceedings can be conducted, it can be conducted. The paper book of that reservation matter was more than 10,000 pages. So different volumes, it can be conducted. There is no issue. About the second part, mindset. Mindset cannot be changed overnight. It will require a consistent effort, which we'll try to make to change the mindset. Let's hope we are successful. Pray for us.
बिल्कुल सर, लेकिन सर अब जब ये बातचीत जो है वो हम अंतिम पड़ाव पर लेके आ चुके हैं, 5 ऐसे सलाह जो आप एज ए जज यंग जनरेशन को देना चाहेंगे, क्योंकि आप वकील भी रह चुके हैं सर, आपने जज की भूमिका की और आप एक अब नई भारत में एक नई तस्वीर लिखने जा रहे हैं आर्बिट्रेशन सेंटर के चेयरमैन के रूप में। 5 वो कौन से ऐसे सर सलाह आप देना चाहेंगे जो एक वकील को और एक जज को ज़रूर मानना चाहिए?
I would say firstly sincerity toward the cause which you are engaged in, sincerity towards your client, sincerity towards the court. Some people think they are too smart. They will be sitting outside the court to say that bimar ho gaye hain. You come to know immediately. In one of the matters before my court, the lawyer made an asked for time at about 3, but his senior is appearing before another court. And that judge was famous that he will finish his hearing before 1. He was very, very fast. He says, impossible, he can't be in court at this moment. So these are some issues which come up. Sincerity. Hard work. There is no shortcut but hard work. You have to prepare your brief not only for the purpose of projecting your point of view, but to be cautious of any misleading statement being made by the other side. So sincerity and hard work, I would say. You can repeat it 5 times or whatever it is. There's only 2 things I would say. So.
थैंक यू सो मच सर। और जब आप ये लगभग 1.5 घंटे हम लोग बातचीत करते रहे और जैसे वक्त गुजरा है और जितनी आसानी से, जितने सहज तरीके से आपने इन सब चीज़ों का जवाब दिया, मुझे याद आ रहा था जैसे गंगा की धारा सर चलती रहती है और सबको प्राण देती रह रही है, ठीक वैसे ही आप आर्बिट्रेशन सेंटर की परिकल्पना को भी ज़मीन पे जिस तरह से आप उतार रहे हैं और उसको प्रसिद्ध करने की कोशिश कर रहे हैं, वो लक्ष्य पाने लायक है। ये मैं इस बात की ताकीद इसी से होती है कि उस सेंटर को आप एज अध्यक्ष संभाले हुए हैं। बहुत बहुत शुक्रिया सर।
Thank you very much. Thanks for best wishes.